So our next speaker is Hugh Scher. He's a very prominent disability lawyer who works in Toronto and Ottawa. And he has taken some of the important and won some of the important cases in Canada that involve people with ME/CFS. So we're very, very pleased to have Hugh speaking with us today. And I think he'll be on the screen momentarily. Hi, Hugh. Right? Thank you.
Hi there. How is everybody today?
Good.
I'm happy to be here.
Quiet group.
I'm happy to be here speaking today. As indicated, I'm a human rights and disability lawyer who has been engaged in this area for over 25 years. My specialty is disability-related human rights, employment, and disability insurance and CPP litigation. And I've been doing these kinds of cases across the country and every province for the past 25 years. I'm also serve as counsel to the National ME/FM Action Network, the ME Ontario, and to a variety of other local ME and FM associations across Ontario and Canada. What I'd like to talk with you about today is the relationship between the employment agreement or the employment relationship people have with their benefits and how that impacts questions around benefit claims, both in terms of drugs and dental, as well as short-term and long-term disability, the import for EI, sick benefits, or CPP, or AISH, as the case may be, and more particularly, how those elements, including return to work efforts, accommodations at work, and the unique nature of ME and FM play into and factor into considerations around human rights related accommodations for people with ME and FM, particularly in the workplace. And likewise, how the unique nature of ME and FM impacts specifically around disability benefit type claims and how those relate between the benefit claim and the employment relationship. So that's the focus I'm going to take today, and hopefully will provide a bit of perspective in terms of how these claims sort of fit into the broader conception of the employment relationship, which is where these claims effectively stem from. In effect, long-term disability benefits are benefits of employment. They stem from the employment relationship that individual employees have with their employers. Individual employees have contracts of employment with their employers, whether they're written contracts or verbal contracts. And those contracts of employment provide that the employee will engage in certain kinds of duties of work, and at the same time will be compensated for that work by way of pay, salary, and benefits. And those benefits will typically include such things as drugs and dental benefits, as well as short-term and long-term disability insurance benefits and life insurance benefits, most commonly. And so the impact is that when somebody becomes sick and disabled by ME or FM, that has a significant impact because it may impact the ability of the individual to effectively carry out the duties of their work, in which case they're not meeting the obligations of the employment contract. And as such, they may not be able to receive the salary that comes from that. In those circumstances, one's typically left with 2 or 3 different options, one of which is to go off on a government-sponsored leave of absence, for example, an EI sick benefits claim that may last for a period of 15 weeks. It may involve a claim to short-term disability benefits or sick benefits from work, if those are granted. And ultimately, if it's a prolonged leave, it may result in a long-term disability leave and accordingly long-term disability benefits, for which typically the employee contributes in terms of premiums. But all of these things effectively stem from the employment relationship and result from the nature of the remuneration agreement that employees make with employers in terms of their employment. So that's the starting place. So it's important to understand, first off, what is the nature of the agreement one has with the employer? What are the actual benefits provided? Do they include short-term or long-term disability benefits or not? If not, then one is left to resort to the government-sponsored circum benefit plans in those instances. For example, EI sick benefits, potentially CPP disability benefits if one's off for a prolonged period of time. It may result in an unpaid leave of absence from the employer until such time as the person is deemed either fit to return to work and no longer disabled from working, or alternatively is off for such a prolonged period of time, usually about 3 or 4 years, to the point where the employment contract becomes frustrated and effectively the employment of the individual is terminated. I'm going to talk to you about the relationship as well between employment terminations and claims disability benefits. So let me start looking again at the employment agreement. So the employment agreement provides for these elements of benefits, including drugs and dental, short-term and long-term disability benefits. These benefits effectively derive from the employment relationship. In the context, they're also governed by a specific agreement, usually called a policy of benefits, as between the employer and the insurance company, both with regard to health and dental benefits, and likewise regarding usually long-term disability insurance benefits. Typically, short-term benefits are paid for by an employer, which most people don't understand. They're actually typically paid for by the employer's money, although they may be administered by a third-party administrator, including an insurance company, who effectively makes the decisions around entitlement, but it's not their money that's actually being paid out for the short-term disability benefits. So let's take the situation of the individual who becomes sick and with ME or FM, is experiencing the kind of pain and fatigue, depression, and low energy that commonly affects people with these conditions and creates an unpredictability and a variability of symptoms that makes it difficult to work. Well, one element is if one is not so disabled because of that, then one can look at a request for accommodations in employment from the employer. In other words, are there things that the employer can do to facilitate the disabled person's ability to continue in work, even if it involves potentially modifications to the job? Perhaps less time at a computer, perhaps less time engaging in physical labor, perhaps a change from a more physical position to a more sedentary or office-like position. These are possibilities that may enable the individual to still continue to work. And I note that about 80% of people or 75% of people with ME and FM actually do continue to work in some capacity, according to the statistics. There are, though, that category of about 25% of people who are so disabled that they're not able to continue to work. And those are the ones who typically come into, at least on a prolonged basis, the claims disability benefits both for LTD and for CPP. But I don't want people to lose sight of the fact that the employer typically has an obligation to accommodate employees in the workplace, including by modifying the nature of the role and the position in such a way so as to enable the person to carry out those duties they're capable of doing, provided it's still meaningful work, and provided that it's not sort of a make-work project, but rather it's meaningful work for the employer that needs to be done, and still is something that's reasonable enough that will enable the employee to carry out the duties of a position and at the same time provide a value to the employer. So it's not always a zero-sum game. It's not always a question of, I have to continue to work full-time and at full throttle, or I have to effectively leave and leave forever. And that can change over the course of time. One can go off for a period of time, and then one can effectively potentially try to return to work. And on that return to work, there may be rights and entitlements under the Human Rights Code for accommodations and for measures to implement to effectively take account of the nature and impact of the disability on the individual's ability to perform their job. And that's something that one may well be served to at some point communicate with the employer, gain the kind of medical background documentation you would need relating to, as my friend said, functional limitations and restrictions, because that's really the key element, is to assess those limitations and restrictions and how they impact your ability to actually do the job that you're doing at that time, or otherwise may be capable to do. So that's sort of the human rights element of it. But then for those people who become significantly disabled and unable to work, they will often try to avail themselves of a short-term disability benefit and ultimately potentially a long-term disability. And the tests for those, as my friend has outlined, are largely that you have to demonstrate effectively that you are disabled from doing the duties of your own job, usually for a period of up to 2 years, depending on the policy. And thereafter, you have to demonstrate, if you wish to receive continued benefits, that you are disabled from doing the duties of any job for which you're reasonably qualified by way of education, training, or experience. And that would potentially entitle one to benefits usually up till age 65 under most policies. Various policies will have different permutations to that definition, but the essence of it is typically the same. Sometimes you may only have an own occupation disability policy. Particularly professionals will often have that. Lawyers, doctors will typically purchase individual own occupation private disability insurance, which is separate from an employer. But most of the employer-based policies are typically group-based policies, which makes it cheaper ultimately. And it also means the difference between the individual and the group policies is that the individual policies are usually underwritten by the insurance company at the time you actually make the application to receive the policy, as opposed to at the time you're actually making a particular claim. So it's a little bit easier in many instances to receive benefits under an individual policy than under a group policy, because the group policy claims are adjudicated and underwritten effectively at the time that you're actually making the claims. That's not to say that the individual policies aren't assessed that way as well, they are. But there is a bit of a difference in terms of how they're perceived. But in terms of group policies relating to employment, again, what happens then when you're on your disability leave, whether it's short-term or long-term? Well, what happens then with my health benefits? Does it mean that if I'm on disability benefits and covered under the policy for LTD or STD, that I'm still entitled to receive my my health and my drug benefits from the employer? Well, the answer is it depends. The answer is that those benefits are not benefits of your LTD policy. Those drug and dental benefits are benefits of your employment. And so, to the extent that one is, for example, applied for short-term or long-term disability benefits and been denied, one is left then on an unpaid leave of absence, and it's an open question and a matter of employer policy as to whether or not they will continue to enable the individual to access those health and welfare benefits during that unpaid leave of absence. Usually, the policy may be that the individual can access them, but they have to pay the premiums themselves rather than the employer paying those premiums. Likewise, the usual policy is that while somebody is on an approved disability leave of absence through LTD, that the employer will typically maintain the drugs and dental benefits without premium to the employees for as long as they continue on that LTD leave and for as long as they remain employed by the company. So at that point, that's a common question I get because people don't always understand how they may lose their access to drugs and dental benefits despite the fact they're believing to be disabled and entitled to those benefits. Because again, they relate to the employment relationship, not the disability benefit contract. It's a bit different with life insurance because most LTD policies have a waiver of premium benefit with respect to both LTD and life insurance, which means that as a term of the LTD policy, there's a waiver of the requirement to pay long-term disability insurance premiums, and there's a waiver of the requirement to pay life insurance premiums, and you continue to receive access and eligibility for those benefits with that waiver of the premium. Okay, that's not the same case with regard to health and dental benefits, for example. So how does that then impact, or is it impacted by virtue of the fact that I may be terminated from my employment? And what if I'm terminated from my employment either while I'm on an LTD leave or before I get the opportunity to apply for the disability benefits? Most LTD policies will have in them a clause relating to termination of employment as a disqualifying factor relative to access to and application for disability benefits. That's not quite accurate. The general rule is that to the extent that somebody becomes totally disabled from work during the course of their employment, then they remain entitled to apply for and potentially to receive disability benefits, even in the event that ultimately their employment is terminated. In other words, if you became disabled while you were working, and by disabled I mean totally disabled from work, and you make the application, usually you'll still be entitled to claim for and to receive those benefits as a general rule. What happens then if your employment is terminated before you have the opportunity to apply for disability benefits? Well, usually on a termination of employment, there are some requirements with regard to providing a reasonable notice. So reasonable notice is determined, first of all, by provincial minimum standard requirements, employment standards regulations. You know, the usual rule for minimum standards is basically a week per year of service, of notice, up to 8 weeks, and another week per year for employees over 5 years of service for companies with payrolls of more than 2.5 million. Those are the mandatory minimums, at least in Ontario, that apply. And there's also a requirement under that same legislation to maintain health and welfare benefits for a period of 30 days after the termination of employment. So to the extent that the employer terminates the benefits immediately, they're usually in breach of that requirement and can potentially be held liable as a consequence of that. The other point I would make is that to the extent that one has their employment terminated and then effectively becomes disabled during the course of the notice period. Let's say the notice period is 12 months or 8 months, because usually it's based on your years of service, your age, your level of employment, factors like that. The usual rule of thumb, if there's not a contractual limitation in the employment agreement that says we're limiting you to a week per year of service, is usually it's going to be a month per year of service of notice for most employees, particularly for higher level management employees and for employees that have been there for a longer period of time or who are older. Okay, so but to the extent that you actually have a situation where you are terminated from employment and yet become disabled after that fact, but within the notice period, the case law has determined that employers, in fact, can be held responsible to cover what you would have received in terms of disability benefits had they not effectively terminated your employment and ultimately denied you the opportunity to gain access to those benefits through the insurer. So either the insurer is going to be potentially responsible, or alternatively, the employer may have to take on that responsibility if the insurer is effectively cut out of the picture improperly by the employer. So that's important to understand, because often when you're sick and you're not thinking as straight as you might normally, it's often hard to navigate these difficult areas. And it's really important to try to get yourself some professional advice from both somebody who understands these areas of law, both the employment law, but also the disability insurance related law. And also somebody who understands ME and FM, because obviously you spend a lot of time having to describe your situations to doctors, and it's so energy consuming having to do that. It makes such a difference to have somebody that actually understands as well or even better than the doctors the nature of your condition, the impact it has on you, the limitations that you deal with on a regular basis in terms of energy, mood, and depression, in terms of physical pain, and in terms of concentration and cognitive difficulties, and how these impact you. I mean, these disability forms and these legal issues are complicated, and they are even more complicated when you're not well enough to work, first of all, and have to contend with these issues that you don't deal with on a regular basis. So I would encourage people who are confronted by these situations to try to gain access to expertise who can help you to try to aid and assist to make sure you're not losing out on your potential rights and entitlements. And that includes the ability potentially to be able to return to work with accommodations if you're able to, to gain access to disability benefits, if that's that issue. And likewise, in terms of a termination, to make sure you're getting a proper package on a wrongful dismissal and what human rights implications may flow from that. Some of the work I do is the day-to-day employment law, disability-related employment, and human rights and disability insurance litigation, and how all of these intersect. Other case law I'm dealing with is dealing with some of the broader questions related to disability benefits adjudication. For example, I did on behalf of the MEFM Association a number of years ago a case called Low and Guarantee Insurance, which basically is a case that created a new legal cause of action against biased medical assessors. Now, that was originally done in the context of motor vehicle accident legislation, but that has been applied to the long-term disability context. So to the extent that you have a disability independent medical assessor that is acting in a biased way, unfairly, and creating a report that is significantly problematic and inaccurate and unfair and biased, there may actually be a potential cause of action against that particular doctor. And that's something that's not always called upon regularly. It's something you should be aware of. It's not something you should use in every instance, but it's something new that is available that you should be aware of. Another case I'm doing right now deals with a challenge on a human rights case out of Nova Scotia, where we were successful in basically gaining access to coverage for health benefits for medical marijuana as a pain reliever, covered by the insurer in that case. And that case is now being appealed by the insurer up to the Nova Scotia Court of Appeal. And so the Nova Scotia Court of Appeal on October 2nd is going to hear that case and determine whether or not, the benefit plans are required to provide for coverage for medical marijuana as a pain reliever. And that case may well have significant implications, not only in Nova Scotia, but across the country. So the first thing I reiterate to you again is looking at the employment relationship, understanding the nature of the roles and responsibilities of the parties under the employment contract, including with regard to benefit coverage, health and dental, STD and LTD, the interrelation with government-sponsored plans, including EI sick benefits or AISH benefits or CPP disability benefits, as distinct with short-term or long-term disability benefits. And again, there are often offsets or set-offs relative to these various kinds of benefits. So for example, if you're getting a long-term disability benefit of $1,000 a month and you're entitled to a CPP disability benefit of $500 a month, then ultimately your LTD benefit gets reduced and the CPP benefit is offset. So you still get the same amount of money, you still get $1,000, it's just split between the CPP disability of $500 and the LTD insurer's payment of $500. So that's something also to be aware of in terms of what the requirements of the policy are, and usually it includes such an offset. I'm going to talk again a little bit about what my friend spoke of in terms of the importance of functional limitations and the uniqueness of ME and FM in addressing these kinds of claims. I'm going to speak about that briefly, because that really is the fundamental issue. For most people with ME and FM, it's such a journey just to validate your experience, that the quest for a diagnosis seems to be what governs the path, both medically and socially, that many individuals with ME and FM follow. But in the legal context, in a disability benefits context or a CPP context, what matters is not what you have, but rather how what you have impacts you functionally. How does it limit you specifically from doing the duties of your own job? So it's important to, first of all, understand what is the nature of your job. What are those specific duties? And how do my specific limitations of depression, cognitive dysfunction, and memory problems, and concentration difficulties, and low energy, and physical pain, and difficulties moving and standing and walking and sitting for prolonged periods, how do those limitations impact my ability to engage in work? If I'm a computer programmer sitting at a computer all day, or I'm a legal assistant typing all day, how does these factors affect me? If I'm a business consultant or a lawyer dealing with complex issues of concentration and memory and focus, how does the effect of my disability impact and limit me in carrying out the duties of that job specifically? That's what you need to be able to determine and to elicit from your healthcare practitioners. And doctors aren't really good at that. They really need to be asked specific questions about functional limitations and restrictions and the linkage to the positions of employment and to any employment after 2 years. Or else the disability insurer is going to seize on that fact to say that you really don't meet the definitions. Often, as much as I would like to say that it's simply insurance companies being difficult all the time, most often in recent times I'm finding that where claims are denied, it's largely because that the individuals have not been able to elicit the kind of medical information about the functional limitations and restrictions and their impact on the job or on the ability of the person to work in any capacity. Is what usually means they don't get approved for the disability benefit. So it's important, fundamental, to be able to elicit that information both personally in your own narrative and your own answers to the questions, particularly medically, even including an occupational health assessment to determine those kinds of things, and or to have your doctors and your specialists. I think specialists are actually quite important, contrary to what my friend said, because I can tell you that's what the insurance companies are looking for. They want to see specialist reports, and specialists to some extent are in a better position, whether it's a physiatrist assessing pain issues or a rheumatologist assessing pain, or whether it's a psychiatrist assessing mood and depression. The family doctor is clearly in the best position with the best relationship to pull all of that information together. I agree with my friend on that. But it's important that one or all of your doctors are effectively swimming in the same direction regarding your limitations and your restrictions, and how those particularly impact your ability to work. And again, with that, I think you'll find that your ability to maintain and support your claim becomes that much more enhanced. The same is true with regard to a CPP disability claim. The need to focus on the limitations and the restrictions and the linkage between those and your ability to engage in any kind of work. And in the CPP context, they've imposed a requirement that that assessment of your ability to engage in any kind of work needs to take place within a real world context. The cases like Villani and Leduc describe that in assessing your entitlement to CPP as having a severe and prolonged disability, preventing you from any kind of gainful employment, the tribunal and the ministry needs to take a real world view of the matter. And they have to assess, it can't be an artificial view of it saying, well, you can be a parking lot attendant, you can sit in a booth and that shouldn't be impeded. But what's realistic given your education, given your age, given your experience? Are you a reliable employee? Are you somebody that can actually be able to attend at work on a reliable, consistent basis? These are factors that are often going to be taken into account. And to the extent that they persist over a prolonged period of time, that then enhances your ability to demonstrate your entitlements, both on the LTD and in the CPP context. And again, if I can help anybody in these areas, been doing that a long time, and I'm happy to do that. I have several cases in Alberta. I work across the country, but it's important to find people that are expert in these areas and that can truly understand the nature of your condition, truly understand the nature of the limitations and restrictions that you experience because of your conditions, and how those relate specifically to the nature of the work either that you have been performing or any other work, and to be able to demonstrate how those limitations and restrictions effectively disable you from performing the duties of any such job. To the extent you're able to do that, your chances of success on your disability benefit claims are that much more enhanced, and your ability to sustain your ongoing employment, because it's not always a permanent situation. And so when I'm usually dealing with these things with people who are still employed, I'm usually writing to the employer and I'm telling them, look, we're disabled now and not able to work, but we are committed to our work. We enjoy our work, we love our work, and we intend to come back once we're deemed medically capable to do so. So don't terminate. And in the meantime, you can provide some medical notes saying that you're engaging in rehab and attempting to improve your situation, but at this time you're not capable to return to work because you remain totally disabled. It's important to keep the employer in the loop just as you're talking to the insurer. there are so many issues of intersection between the employment and the disability benefits areas. I could talk here for all day, but I appreciate your time and attention here. I hope this addresses some of the common questions that you do have. And again, if there's any questions I can answer with my friends, I'm happy to do that. And thanks again for having me today.
Thanks, Hugh.